Good afternoon, everyone. My name is Laura Iñigo Álvarez, and on behalf of the Nova School of Law and the Nova Center on Business, Human Rights and Environment, I would like to welcome you to the second episode of this webinar series on business, human rights and environment in Europe, connecting the dots. Today's sessions will focus on the interconnectedness between corporate due diligence and private international law in light of the legislative developments at the European level. This webinar series is organized with the support of the Portuguese Presidency of the Council of the European Union and is held in partnership with the Portuguese Ombudsman, the British Institute of International and Comparative Law, the Teaching Business and Human Rights Forum, and the Nova for the Globe. So welcome to all the speakers and the members of the audience. I would like to introduce the chair of this session, Alexander Layton, who will explain the program and the format of this webinar. Alexander Layton is a practicing Queen's Counsel at 20 Essex Chambers in London and a visiting professor at King's College London. He's a specialist in private international law and has acted as leading counsel in several high-profile corporate responsibility cases, as well as a wide range of other cross-border work, including before the Court of Justice of the European Union. He has been a visiting lecturer at New York University Center for Transnational Litigation and Commercial Law, and has lectured in many university and professional settings in Europe and beyond. Among other published work, he is the co-author of European Civil Practice, a leading work on the Brussels-Lugano regime. So please, Alexander, the floor is yours.
Thank you very much, Laura, for that generous introduction. My job today will be to try to make the webinar run as smoothly as we can. We have a very large and distinguished panel of law professors and practitioners who will discuss this topic, and they are uniquely well placed to discuss the proposals from the European Parliament. I will not introduce them as fully as Laura has very kindly introduced me, because the short versions of their CVs are going to be posted into the chat during the course of the webinar so that you can see more about them. But very briefly, they are in the order in which they will be making their presentations. Professor Marc-Philippe from the University of Heidelberg and Claire Bright from the Nova University will first of all discuss the global environment in which the topics that we're going to be discussing today arise. Before we then move on to the private international law areas, the proposal is that we will have that as an introduction, and we will then move straight to the next topic, which will be the role of private international law in providing a forum against parent companies and subsidiaries and co-defendants in Europe for worldwide type activities. And that will be a jurisdictional discussion, which will be led by Professor Catherine Kessedjan from the University of Panthéon-Assas in Paris, and by Geert Van Calster from the University of Leuven, both of whom will be very well known to many of you. There will then be a panel discussion involving all our panelists with brief contributions on the jurisdiction topic before we move to questions and discussion. And so that will be the first part, really, of the webinar. And the second part of the webinar will involve a presentation, a joint presentation by Professor Angelica Bonfati from the University of Milan and Dr. Eduardo Álvarez-Armas from Brunel University in London, who will discuss applicable law questions. And we will then have a panel discussion with the other panelists discussing that aspect as well, before moving to questions and discussion. So that's the order of events for today. What I would ask participants to do, please, is if you have questions or comments, please put them in the Q&A box on this Zoom webinar. You'll see at the bottom of your screen, probably at the bottom, maybe elsewhere, a little pair of quotation bubbles with Q and A written underneath it. So type those in there and we will see those. And if we get a sufficient opportunity, I will put some of those and maybe even all of them if we can manage to the panelists in the question and discussion periods. So I'm afraid my job is that of now being a neutral referee and timekeeper because we have a distinguished but large panel of speakers. And so we have quite a lot of time to take in discussing this topic. So without more ado, I will start by inviting Marc-Philippe Vella and Claire Bright to give their presentations by way of introduction to the topic. Thank you.
Thank you very much, Alex. And I will now share my PowerPoint slides with you. So as a start for my presentation, I would like gives rise to an obligation to provide remedy. And the very notion of rights would be meaningless.
I'm sorry to interrupt. We lost sound from you there for a moment. Would you mind just going back over that, please?
Of course. I was just saying the notion of rights itself would be meaningless without a mechanism to ensure access to effective remedy when breaches do occur. And this is something that the UN Guiding Principles on Business and Human Rights recognize. In particular, the UN Guiding Principles clarify that states are required to ensure that when business-related human rights harms do occur within the jurisdiction of states, those affected have access to effective remedy, and that states should take appropriate steps to ensure the effectiveness of their domestic judicial systems and consider ways of reducing legal, practical, and other relevant barriers. Yet, numerous studies have documented that many hurdles to accessing remedy faced by individuals and communities whose human rights have been adversely affected by corporate activities in practice. In 2019, we undertook a study for the European Parliament where we mapped out all the relevant legal proceedings that had been filed in Europe against European-based companies on the basis of alleged human rights and environmental abuses in third countries over the past decades. We looked at 35 cases in particular, out of which only one led to a positive judicial outcome on the merits for the claimants. And this was a case of corporate criminal liability, which involved the supply of weapons by the CEO of a company to the Charles Taylor's government in Liberia in exchange for timber concessions, quite an extreme example. Since the study was published, we now have the first positive judicial outcome for the claimants on the merits of a case in a civil liability case against a corporation. And this was just a few weeks ago in the ruling against Shell, and I know my colleague Chukwuma will be talking about that later on. So in our study, we identified amongst the recurrent legal obstacles that claimants are facing to accessing remedy, that several of these obstacles were linked to private international law rules, which in their current form are ill-adapted to the specificities of cross-border civil claims arising out of alleged corporate human rights abuses. And I will now turn to a couple of concrete examples from the case law to illustrate some of these examples. Starting with the jurisdictional issues that arise out of the Brussels I recast regulation, I would briefly like to talk about the Vedanta case. This is a case that involved civil proceedings that were brought in the UK by Zambian citizens against both the UK domicile parent company, Vedanta, and its Zambian subsidiary. They were claiming reparation for the damage that they allegedly suffered as a result of the toxic emissions from the copper mine in Zambia that was owned and operated by the Zambian subsidiary. And in this case, the English courts asserted their jurisdiction over the parent company on the basis of Article 4, combined with Article 63 of the Brussels I recast, which I have reproduced here on the screen, since Vedanta was domiciled in the UK. However, the application of the Brussels I regulation is limited to EU domicile defendants, meaning that it is a domestic law of the forum which determines the residual jurisdiction over non-EU entities. So what that means concretely is that, as against a Zambian subsidiary, the claimants had to rely on English domestic rules, and in particular paragraph 3.13 of the Practice Direction 6b, which I have reproduced here on the slides. In this case, the defendants challenged the jurisdiction of the English courts, in particular over the Zambian subsidiary, and this led to lengthy discussions on the issues of whether there was a real issue which it was reasonable for the court to try between Vedanta and the claimants, and whether the Zambian subsidiary was a necessary or proper party to the claim as required by the English rule. Now, in the time frame that I have been given, I will not enter into the details of the judgment, which was very significant in several respects, but would simply like to point out that it took 4 years just to reach a decision on these jurisdictional issues. And in fact, in the Supreme Court, Lord Briggs commented on the disproportionate way in which the jurisdictional issues had been litigated, the voluminous pleadings, and the need to avoid a mini trial at such an early stage of the legal proceedings. And I've reproduced a quote here that he used, quoting another judge in another judgment, where he said, "It is self-defeating in order to determine whether an action should proceed to trial in this jurisdiction if the parties prepare for and conduct a hearing which approaches the putative trial itself in terms of effort, time, and cost. There is also a real danger that if the hearing is expensive and time-consuming, it will be used by a richer party to wear down a poorer party." And I think this warning is particularly relevant in the field of business-related corporate human rights claims, which are often characterized by significant imbalances of powers between the parties. Now, similar jurisdictional challenges were also faced by claimants in other cases, including in the recent Shell cases, which concern disputes which arose out of some oil spills and resulted in environmental damage which affected the lives and livelihoods of communities in the Niger Delta. Here, separate proceedings were filed by 4 Nigerian farmers in the Netherlands against the parent company, Royal Dutch Shell, headquartered in the Netherlands, and its Nigerian subsidiary. In parallel, 2 other groups of Nigerian villagers from different villages filed claims in the UK, where Shell had its registered office. And even though the respective courts eventually allowed the claims to proceed on the jurisdictional grounds, the discussions on whether the jurisdiction of the courts should extend to cover the connected claims against foreign subsidiaries were very lengthy, created unnecessary delays, and added to legal costs. And against this backdrop, I believe that regulatory reform is needed in order to shorten and simplify the proceedings and ensure effective access to remedy. And I know that the other panelists will be discussing what such regulatory reform should look like exactly. Now, once we have passed the stage, the jurisdictional stage, the next question which arises from a private international perspective is the one of the applicable law. And here again, several cases have shown that the issue of applicable law can constitute a significant barrier to accessing legal remedies for victims of human rights abuses allegedly carried out by EU companies in third countries. Under the Article 4.1 of the Rome II regulation, the law applicable in this sort of cases is the law of the place where the damage occurred. Now, going back to the Shell case in the Netherlands, what that meant precisely was that Nigerian law was applicable. And in the first instance, the District Court of The Hague had actually originally dismissed the claim against the parent company on the ground that under the applicable Nigerian law, there was no general duty of care for parent companies to prevent their subsidiaries from inflicting damages to others through their business operations. The difficulty was circumvented in that particular case by the Court of Appeal by considering that English common law cases had a persuasive authority in Nigerian law as a common law system, but we can nonetheless see the limitations of that approaches, pointing to the law of the host state. And this is my final remarks here, but this is particularly problematic given that very few countries in the world have actually adopted legislations requiring companies to have processes in place in order to fulfill their responsibility to respect human rights. France was the first one to do so in 2017 with the introduction of the duty of vigilance law. Netherlands followed suit in 2019, but just in relation to child labor. And now if the EU adopts a legislation on mandatory human rights and environmental due diligence, it will be a pioneer. So it will be necessary to ensure that those higher standards are upheld, not only in relation to the harms which occur within Europe, but also in relation to business-related harms of EU companies outside of Europe. And I will stop my presentation here, as I think I'm running out of time now. Thank you.
Thank you very much, Claire. And we'll move, without further ado, straight to Professor Marc-Philippe Vella, who will further address this topic.
Yes, thank you very much, Claire, for introducing, and thank you, Alex, for giving me the floor. I will have the pleasure to discuss the role of substantive law concerning the human rights litigation. And the starting point is in the last century. In the 1970s, the famous economist Milton Friedman stated the social responsibility of business is to increase its profits. And you all know that from there, the so-called shareholder approach was the predominant approach, the predominant principle in business. The interests of the stakeholders, that means third parties, employees, and so on, weren't taken into account. And from there, multinational companies established themselves and they began to externalize their risks. How did they do that? The first aspect were the supply chains, global supply chains with independent subcontractors, with independent suppliers on the one hand, and huge group of companies with parent companies in the so-called global north and subsidiaries in the global south. Often there was then a governance gap in the global south. There were standards which are inferior than compared to the global north, and those multinational companies used these gaps to increase their profits. We observe human rights violations, especially in the subsidiaries, in the subcontractors and suppliers abroad. That means in the global south. Now, if you are a victim of such a human rights violation, of course you can sue the supplier, you can sue the subsidiary in the global south. There are established legal systems. However, you face two problems. The one main problem is the risk of insolvency. Often such subsidiaries and subcontractors are illiquid or not enough, or don't have enough assets to be seized if you have such accidents like Claire showed in the Shell and in the Vedanta case. And the second aspect is that sometimes the legal systems are not as well developed as in the global north. That means you have sometimes corruption, sometimes you have a lack of independence of justice, so that often the multinational companies will win those proceedings and not the victims of the human rights violation. And that has led to a movement towards the global north in the last years, where we can observe the so-called human rights litigation. It began first in the United States, but then came over to Europe, and Claire demonstrated showed us some prominent cases of the UK and of the Netherlands, and also in Germany. And I think it's also fair that the mother companies yeah, that they must bear the damage. We have a famous German economist, Walter Eucken, who said, who has the benefit of an undertaking must also bear the damages and the risks of this undertaking. And that means if you establish supply chains and if you establish a global group of companies, that you also have to bear the damages resulting from such supply chains. And the discussion went on the level of the United Nations, and the United Nations established the so-called guiding principles on business and human rights, also called the Ruggie principles. We have 3 pillars, and our topic today is focusing the second pillar. You can see here the corporate responsibility. In those principles, it is established that large corporations have a so-called human rights due diligence, a duty to establish a due diligence vis-a-vis the respect of human rights. However, there's one problem of those UN guiding principles. You all know that they derive from public international law, and in addition, it's a soft law instrument. And that means they don't impose duties for private actors. They only oblige states. Of course, the states have now the duty to protect employees, for example. And how can they do that? Well, by establishing delictual law, tort law, for example, or company law aspects. And one of those instruments we are discussing today is the proposal of the European Parliament. To show you a prominent case from Germany, we have the so-called KIK case. KIK is the abbreviation for Kunde ist König. It's a textile discounter company, and it produced in factories in the global south, inter alia with Ali Enterprises Limited, a company in Karachi in Pakistan. And there was 5-6 years ago devastating fire. We had a lot of injured, a lot of death, and the victims afterwards claimed damages from KIK, the mother company, or the contracting company in Germany before German courts. And if you look this triangle, that's typical for such cases. We have on the one hand the victims, the later claimants. Then you have the supplying companies. Here in this case, Ali Enterprises in Pakistan, and you have the company in the global north, here KIK GmbH in Germany. And the claimants argue, typically in those cases, that the company in the global north, in Europe, that they are able to influence the production process abroad. Why? Because they are the main customers or even the parent company of the group. And deriving from that influence, that you have a tortious duty of care regarding not only the employees of the mother company, but also of the subsidiary or the supplier. And in a more abstract way, you can see that you have, as I said, the parent company or the retailing company. You speak in the group of companies, you speak of a parent company and a subsidiary. In supply chains, you can say it's a retailing company and a supplier or a subcontracting company. And you have then the victims. But the victims, and that's now the important aspect, they only have a contractual relationship with the subsidiary or with the supplier. That means normally they are employees, for example, and they are suffering from the bad conditions, the bad working conditions in those countries. And the question is, how can you establish a liability of the parent company? And there are different approaches. One approach is when you have a contractual relationship between the victim and the subsidiary, you can pierce the corporate veil of the subsidiary to seize the assets of the parent company in the case when the subsidiary is insolvent. That would be an approach. However, it's difficult to establish because it's a company law approach, and the question of private international law would be which law is applicable to the piercing of the corporate veil. And probably it's the law of the subsidiary. I think that's the prevailing opinion. And that would pose problems Why? Because we would then have to assess and evaluate the foreign law from a European perspective, which is always difficult in such cases. That's why the second approach is more convincing. It's the approach via tort law, via delictual liability. And here you have two possibilities. The first one is the so-called vicarious liability. That means the liability of the parent company for another person, here for another legal entity, the subsidiary. However, the problem is that this other person is not a natural person. It's not an employee of the parent company, but it's an independent company. So that the establishing of a vicarious liability would need an act from the legislator. It's not easy to establish. And the second aspect, and that's what the European Parliament is focusing now, the second possibility is to establish a duty of care of the parent company. Of course, you have also a duty of care of the subsidiary vis-a-vis the employees of the subsidiary, but a second duty of care of the parent company. And the question now is the reach, the scope of this duty of care. Is it limited to the legal entity in question? I mean, is it limited to the parent company? Is the parent company only responsible for the employees of the parent company? Or can you extend this duty of care to the subsidiary, to suppliers, and a so-called duty of care, which is now also in Article 4 of the proposal of the European Parliament. That's are the approaches of the substantive law. And you can imagine that it gets even more complicated when we now discuss the question of the forum. Where can you sue those companies? And what is the applicable law? Because this is the decisive question, the decisive predominant question. Thank you very much.
Thank you very much, Mark. That's very interesting and important introduction to it, so that we can understand the context in which today's discussion will happen. There'll be plenty of opportunities to come back for discussion about that. I should say next that I apologize to Dr. Chukwuma Okoli because I didn't introduce him in my initial round of introductions, and I'm very happy to do that now. He is at the well-known TMC ASA Institute in The Hague, and I've asked him whether he would make a brief comment at this stage on this first topic that our first two speakers have addressed before we move on to the private international law aspects. Chukwuma.
Yeah, thank you very much, Alex, and thanks, Claire and Mark, for your presentation. I'll be talking a bit about the Shell case, which Claire mentioned. In that case, there were actually 4 Nigerian farmers and a non-governmental organization from the Netherlands that sued Shell's subsidiary and its parent company in the Netherlands. The subsidiary is actually one of Shell's subsidiary is actually located in Nigeria, while the parent company was actually located in Netherlands, domiciled in the Netherlands. So there were jurisdictional challenges to brought by Shell to the claimant's case. And the facts of the case was that there was oil spillage that occurred in Nigeria, alleged oil spillage by Shell that occurred in Nigeria. And the claimants was telling Shell to remedy the oil spillage and to pay compensation for it. Now, the interesting issue that arose in Shell was the issue of access to justice, the jurisdictional issue. And I also talk about the applicable law issue, because the Shell actually said that there was no reasonable prospect of success on the claim against its parent company, because it was actually a subsidiary that was alleged to have carried out those alleged environmental damage in Nigeria. So the applicable law was Nigerian law. There was no contest on the applicable law as to whether it was Dutch or Nigerian law. Both parties agreed that the applicable law was Nigerian law, and they relied on Nigerian law in the case. So on the issue of jurisdiction, the Dutch courts actually applied Article 7 of the Dutch Civil Procedure Code, which holds that when there's sufficient coherence between two defendants, they can join both cases in the Dutch court, and the court held that there was sufficient coherence in this case. But the important thing was that it took about 6 years for this issue to be resolved in the Dutch court, from 2009 to 2015, just on this preliminary issue of jurisdiction. It took about 6 years. You know, in total, the case took about 11 years to be completed on a substantive issue. Now, if there was a clear private international law provision on corporate due diligence and human rights abuses, this case wouldn't have taken this long to have been completed. There would have been an obvious legal basis to hold that there was that the parent company and his subsidiary in Nigeria could be sued in the Netherlands. There would have been an obvious legal basis, and that's what the proposal is trying to. The new proposal on Article 8.5 of Resource 1 recast is trying to achieve. We'll talk about that later. Then another issue was the applicable law, which I'll briefly talk about. Although there was no contest on the applicable law being Nigerian law, the court actually held that there was a duty of care from shell parent company to the claimants in ensuring that the subsidiary carried out its activities properly to the claimants. But I actually questioned the way the court actually applied, the Court of Appeal applied Nigerian law, because if you look at the Nigerian Supreme Court cases, it hasn't advanced the way English law has advanced to hold the parent company liable for the acts of the subsidiary on the basis that the parent company owes the claimants a duty of care. So it hasn't advanced that far. And under Nigerian jurisprudence, it's clear, the law is that the parent company and subsidiary are separate entities. The parent company can only be held liable where the subsidiary is an agent of the parent company. That's the only condition the parent company can be held liable. So the way the Hague Court of Appeal was applying Nigerian law was a way of circumventing the Nigerian Supreme Court decision, you know, and it was, in all honesty, it was a way of developing Nigerian law, the way it has not been developed in the past. It was developing Nigerian law. So this is actually an important issue, because if in such situations, the claimant should be able to have choices as to what law should apply. Instead of just relying on Nigerian law, you should be able to rely on other provisions of the law. So this actually an issue that can be addressed on the Shell case as well. You want to say something, Alex?
No, I was just going to say, I think we will come to this question of applicable law and how it affects it in the later part of the webinar. Maybe we should try to stick to our timetable and move on at this stage. But the topics you've raised, Chukwuma, if I may say so, illustrate the importance of private international law, because resolving the applicable law question, resolving the jurisdiction question, defines the settlement landscape. And after that, the parties can then assess the extent of their liability or their prospects, and very much more frequently reach a settlement of their differences rather than having to take them to a full trial. And it's in the light of that that I think that the judges who are hearing long fought out jurisdiction battles fail to appreciate that actually that battle is often even more important than the battle on underlying liability. Chukwuma, if you'll excuse me now, I will hand the floor to Geert and Catherine to address the question of jurisdiction.
Perhaps, Catherine, if it's okay with you, I will go first, because I have some slides which just show the text of the proposed amendments to the jurisdictional angle of the topic under discussion. That's also how Catherine and I pre-discussed how we would structure our discussions. So I'll try and share my screen so as you can see those amendments, which hopefully should be visible to you now. Thank you for the previous speakers for introducing the topic, because it gives you, I think, a very good and also necessary context to how these or the general topics in which these litigations take place. So clearly, as our chairman has pointed out as well, and as the previous speakers also showed in bringing up the experience with some of the cases in the member states, what is going on at the moment is that there is an often frustrating and long, extensive discussion in national courts about the very jurisdictional basis on which one could take either the mother corporations in the EU to court on the basis of human rights violations and general due diligence violations across the value chain globally, or indeed the extent to which one could pull the subsidiaries and or other parties in that value chain into the courts of the member states. And what the proposed amendments to the Brussels I regulations, because that's the jurisdictional basis on which we are mainly focusing for this issue, what they suggest is to effectively do two things. One of them is on this very first slide, which is to at least seemingly expand a jurisdictional basis in Article 8 of the Brussels 1A regulation. The second element, which will come in a minute, is to introduce what is called the forum necessitatis in Article 26 of the Brussels 1A regulation. Now, excuse me, I am involved in some of these cases in the courts in England and Wales and in the Netherlands and Belgium as well. So I tend to look at these proposed changes often not just from a scholarly point of view, but also from the point of view as to whether they would actually change anything in practice or indeed confuse. And I think a general thread perhaps in my analysis of these issues is that in my experience, one has to be cautious in introducing how well intended as they may be, on introducing new rules into either jurisdictional basis or applicable law, and indeed that one has to make sure that if one introduces them, that it's very clear what the conditions of application are, because otherwise one simply inserts an extra layer of complexity in which, as we've discussed, in an area in which there's already very long-winded jurisdictional battles, as has been pointed out in the Netherlands, but also indeed in England and Wales. So if you look at this particular new paragraph 5 of Article 8, it suggests, as you can all read yourselves, that an undertaking domiciled in a member state, presumably over and above its place of domicile, and its place of domicile is something which Article 4 of the regulation, which would already guarantee as a place where one can be sued, that it could also be sued in the member state where it operates, but only when the damage caused in a third country can be imputed to a subsidiary and so on, as you see there. So that's the link which is being made between the newly proposed directive on corporate due diligence and then the Brussels 1A Article 8.5 anchored jurisdiction, as it is often called. I am not really sure, but perhaps I don't see clearly what the idea is here, but I can't really see what this actually adds to what we already have at the moment. At the moment, as suggested, one can sue an undertaking, any undertaking in the EU on the basis of Article 4, Brussels 1A, on the basis of, or for claims that basically relate to almost anything. Of course, whether one will be successful in those claims is a different matter. But at the jurisdictional basis, the starting point is that it is very easy to sue a corporation in its member state of domicile. So this is why I suggested that the one invention seems to be here, that you could also then sue in other member states where this corporation, quote unquote, operates. It's not made clear at all what this operation would be. Would it be simply that one offers one services and goods in those other member states? Would one have to have some sort of an establishment in that member state? None of that is made very clear. I also really do not think that it would add much in substance to the possibility which claimants already have. And the cases that have been discussed, for instance, I don't really think that the claimants in the Shell case in the Netherlands would have found it very useful to also be able to sue in Sweden, in Croatia, or indeed in Portugal. So I'm not quite sure what this really would add. But also, importantly, the proposal as suggested does not clarify anything as to what, in my experience, is one of the most important stumbling blocks at the moment in suing mother corporations for damage occurring outside of the EU, which is the infamous Article 33, Article 34 of the Brussels 1A regulation. Those of you in the seminar, and it's great to see that there are many in the seminar, those of you who are not familiar with private international law, just briefly, Article 33, 34 allow a court in a member state to stay a case, in other words, to at least temporarily not judge upon a case if there is a related proceeding outside of the EU for which what is called the sound administration of justice would justify that the case in the EU is being stayed, right? So in other words, there's a proceeding pending outside of the EU, and the court in the EU member state can then say, well, this proceeding is so closely related to what we are discussing here that the sound administration of justice demands that I stay my case and no longer discuss it. Those Articles 33, 34 at the moment are being litigated mostly in England. Of course, that would change, or that has changed post-Brexit. There's still a series of cases that have been introduced pre the Brexit date, so they will continue to have importance. It's being litigated in England and Wales, famously, for instance, in a case called Municipio de Mariana, which is a case concerning one of the collapsed dams in Brazil. In that case, the judge in England at the moment is putting all sorts of obstacles in our way to be able to sue a mother corporation, which has its headquarters in London, to be able to sue them because it is suggested there are related proceedings in Brazil. So I think if there is an area, and we've had to appeal there, we haven't been given permission to appeal by the judge itself, so that's now going to the Court of Appeal. But it illustrates how Article 33, 34, unless there is some clarification, arguably there already is in the Brussels 1A regulation, but unless further direction is given to judges how they apply these provisions, I don't think an article like Article 8.5 actually adds much at all. And indeed, in the Parliament's report, Article 33, 34 is not being discussed. Moreover, when you see at the very last bit of this proposed insertion, you will see that there is some kind of a merits review, because the Article 8.5 additional jurisdictional ground will only be triggered when this particular behavior can be, quote unquote, imputed to a subsidiary or another corporation. So there needs to be, therefore, some kind of a merits review in the Article 8.5 jurisdictional anchor, which again, I don't think will add much to assist with a speedy completion of this jurisdictional exercise. Going then to the new Article 26A, which is this forum necessitatis idea, and the emphasis, of course, in this proposal is my emphasis. So the core of this idea is that you introduce... Yeah.
May I interfere, because we have decided in preparation of this seminar that I would come and discuss, for the clarity of the discussion, 8.5 before you turn to forum necessitatis.
Okay, please, yes, do. So I'll go back to that slide, and then you can add your. Thank you, Catherine. I apologize.
And I'll give you the floor after my comments, so that we discuss forum necessitatis. Alex, I'm sorry I took your role on this. Well, good afternoon, everybody. It's a pleasure to be with you on these difficult topics. I would basically say I'm not going to save the proposal of Article 8.5. So I should make that very clear from the very beginning. I don't think 8.5 is a good provision. And I will tackle it from a different angle than Geert just tackled it. First of all, I want to say again that at jurisdictional level, we need to have simple rules, effective rules, and we need to have a very minimal level of evidence asked from claimants. Because this is jurisdiction, the case has not been tried yet. Claimants must not be obliged to go through an evidence phase which is so cumbersome that they will not be able to actually have jurisdiction in the court. So I insist on that because it is really important for an effective access to justice. My second point is that we need, well, in fact, we need to take stock of what we have. If we are talking about suing corporations who are domiciled, and I'm using the word domicile in the EU meaning, and I hope everybody knows what it is because that's very basic. But if we are talking about suing corporations based in the EU, as this provision that is on your screen shows, we have everything. We don't need more. Article 4.1 of the Brussels I regulation allows anybody in the world to sue an EU-based corporation for any activity in the world. This is what we call in our jargon in private international, this is a general jurisdiction rule. It means that whatever the acts have been, even outside the EU, they are already catched by Article 4.1. So we don't need this kind of language that we see in the proposed Article 8.5. Now, if we want to attach other corporations, other defendants which are not in the EU, and that's when Claire was talking about Vedanta or the Shell case or the Kik case that Marc-Philippe was mentioning, that's exactly the problem. We try, and when I say we, is that the claimants need to attract before the same EU court. When I say EU court, I mean a court based in an EU member state. So when you want to attract corporations that are based outside the EU, then you have the problem. Because Article 8.1 of Brussels I is limited to corporations in other member states. So Article 8.1 does not allow the joinder of other defendants before a member state court in the EU of corporations that are outside the EU. So we need an Article 8.5, or at least I would say we need an Article 8.1.2 because we need to leave Article 8.1 as it is, but then we need to add one paragraph, and it should be simple to draft, that this rule, the rule in Article 8.1, is actually also possibly used in business and human rights cases, whatever you want to draft on this. This is not my problem here, but for corporations based outside the EU. That will solve Vedanta, Shell, Kik, and all the other cases that we have seen so far. And again, we can discuss more in detail whether the limitations that we have in 8.1 right now need to be imported in business and human rights 8.1.2 as I proposed. Frankly, my position on this is not yet completely firmed. We may have good arguments to say that the limitations are too strenuous for the claimants in those business and human rights cases, but I can see arguments to the contrary, but that's the kind of problems that we need to discuss. And I will leave it at here because I think all the other arguments that Geert mentioned before, together with mine, show that Article 0.5 should not have any chance to survive. But we need something. That's the problem. I think the Parliament saw that there was a problem, but didn't propose the proper rule. Geert, you can go to forum necessitatis if you want.
Thank you, Catherine. I'll hand the floor back to you because I'm not sure that you're quite finished.
Thank you very much.
I am done.
So I will just quickly, and I'll stop the sharing in a minute when I've just shown you the slides so that we are all on the same page and you're familiar with it. So this is this forum necessitatis idea, where you can see that effectively the EU courts could be used as a sort of a court of last resort if for all sorts of reasons there is a problem with access to courts outside of the EU. And you see the conditions that are attached to that, including at the very end of that provision, the condition that there be what is called a sufficient connection with the member state or the court ceased. So here as well, and I'll stop the share so that you can just see me properly, here as well, I think there are indeed similar concerns as the one as Catherine just pointed out. This forum necessitatis rule clearly would be an extra, a completely new forum that would be added to the arsenal of Brussels 1A. It's in fact like the proposal that Catherine just underlined, which is to expand jurisdiction on the Brussels 1A to corporations outside of the EU, if the case is sufficiently closely related to cases in the EU, etc. Both those proposals were also made by the European Commission when they reviewed the main jurisdictional rules of Brussels 1 back in 2012. And it was in fact the European Parliament which rejected these proposals, not because they don't believe, of course, in the relevance of sound administration of justice for business and human rights and other cases, but because they pointed out that the more the EU expands its jurisdictional rules for cases that have less of an immediate link with the European Union, the more, of course, it is likely to be confronted with existing proceedings elsewhere, the more also it is likely to be confronted with policy concerns about the EU interfering in issues which are not necessarily of their business. So it's somewhat surprising, I suppose, to see that despite there not having been at the jurisdictional level much international cooperation since, although of course at the substantive level at the OECD, etc., there might have been, that this is now being proposed again, although by Parliament this time, and again without any detail as to what, for instance, that sufficient connection might be. But I'll leave the floor to Catherine to add her thoughts on Article 26 as well.
Well, I will join Geert by saying that it is a bit surprising that we are having a forum necessitatis proposal, but to the benefit of what the European Parliament has done this time, it is limited to business and human rights. And in that, that's why historically, we cannot really take stock on what has happened when the regulation was up for reform, because at that time, the forum necessitatis was a general rule. Here we are talking just on the business and human rights. So I think the policy is correct. I would support a forum necessitatis. And in fact, I have written about that in other circles. I have been auditioned by other institutions on that. And so I have not changed my mind yet. So we need a forum necessitatis. Now, the one problem I have with the proposal by the European Parliament is that it imports the Knight-Lehman case of the European Court of Human Rights. You remember perhaps that in the Knight-Lehman case, which was not a good case in my view for forum necessitatis, because it was a fairly complicated factual case, and it was certainly not the kind of business and human rights that we are talking about. But I can see exactly the language that was imported from there. And I don't think that's good. The reason is that again, if you look at private international issues, jurisdiction, the classic jurisdictional rules are based on sufficient link. This is what we are, all the rules that we have created in Europe for jurisdictional purposes are showing a sufficient link. So if in the forum necessitatis context, you are asking again for a sufficient link, that means that otherwise the court would have been would have had jurisdiction. So it's not a forum necessitatis. In fact, if you want to have a true forum necessitatis rule, you need to say there must be a link, even a tenuous link, with the local court. And I will give you an example that comes from a French case. It was an arbitration case. So it, again, not a proper comparison with business and human rights, but it shows you the kind of very tenuous case that you need for forum necessitatis, which, by the way, is different from universal jurisdiction that we have in criminal cases, or in any civil case if it were accepted, which is not as of yet. The kind of link you need in this arbitration case, it was an ICC case. And because the ICC is headquartered in Paris, the French Cour de Cassation said that the simple fact that the arbitration clause mentioned that it was an ICC arbitration was enough to grant on a forum necessitatis basis to French courts the jurisdiction to compose the arbitral tribunal, because there was an obstacle to the composition of the arbitral tribunal. It's a very tenuous link. Just the fact that it was the ICC mentioned in the arbitration agreement, sorry. So what I'm saying is that this is the kind of tenuous link that we need to ask for forum necessitatis, but no more. And the reason why I am criticizing Leighton, even though, and even more because it was the European Court of Human Rights, Leighton was a properly, legally refugee in Switzerland. If that is not a sufficient link, then I don't know what a sufficient link is. So that's why I'm saying Leighton should not be followed. There were other considerations in the case that explain why the court was so stringent with the poor guy. But I think the European Union should not follow that. Thank you.
Thank you very much, Catherine and Geert, both of you, for your exposition of that topic. We now give the other panelists an opportunity to comment on the jurisdictional stuff. So we have a discussion among the panelists on that. Before we do that, let me alert you to some various questions that have been raised in the Q&A so that they can form part of the discussion as well. We had one question from Katerina Aristova about whether it meant that jurisdiction over connected claims against foreign subsidiaries of EU-based parent companies would still be asserted on the basis of the domestic rules of private international law, taking into account the differences in national laws of member states. Victims can then face more jurisdictional barriers in some states than in others. Does it diminish the value of having an EU-based rule if access to the justice process is different in member states? That's her question, and I see that Geert's providing some written answer to that. We have questions from Professor Geneviève Sommier, who is, of course, very well versed in all these matters and a distinguished contributor to international debates on all these issues. She says, following on from Catherine's argument, isn't the issue of whether the subsidiary or supplier must be joined as a defendant a question of domestic procedure prior to being a private international law issue? Indeed, if the claim is that the parent company is liable, what is the obstacle to suing only that parent? All of the lengthy debates in the UK and Netherlands were caused by the attempt to include the subsidiary, and she points out that the numerous claims brought in Canada against Canadian parent companies did not include attempts to include the foreign subsidiary or supplier as defendants. Those are very interesting topics. I would just add two further points for the discussion, if I may. One is whether Article 63 is being interpreted in the right way as defining the domicile of a defendant. Certainly there's English case law that defines the central administration rather narrowly, we're referring only to the administration of the parent company rather than of the subsidiary, which is regarded as being administered by its own board of directors in its own location, even if it does everything the parent company asks of it. And the second point is merely to point out, in response to a point that Catherine made, that of course the recast regulation in 2012 gave a jurisdictional basis against consumers, against suppliers to consumers who were themselves outside the member state. So we already have adopted a rule of jurisdiction over non-domiciled defendants in a comparable area. Right, so we'll move now, and I will go in the following order to the panelists who haven't yet spoken. I'll go first to Angelica Bonfati. Angelica, do you want to make any comment on the jurisdictional aspects?
Yes, thank you, Alexander. Can you hear me?
Yes, that's fine.
Okay, thanks. First of all, let me thank the previous speakers for their comments, and I have appreciated them very much. Just very few comments from my part. I basically appreciate the amendments on the Browser-Bar regulation, especially the forum necessitatis, as it seems to me that it will be decisive in order to grant an effective access to remedies for victims of corporate human rights violations, and especially in order to avoid victims from poorer countries where potentially lower standards on human rights are applied to have access to remedies somewhere. As concerns Article 8, Paragraph 5, instead, I share the same perplexities as Catherine and Geert. But at the same time, it seems to me that this article, even without providing for an effective solution, touches upon an aspect that is still unresolved and that needs to be taken into consideration properly at the European Union level. That is, that the wording of the article explicitly refers to the hypothesis that the tort is committed not by a subsidiary company, but by an undertaking within with a business relationship. So somehow it seems to provide a solution, even not an effective one, to those cases, such as the cases mentioned before, the Kik case or the Rana Plaza case, where the tort was committed not by a subsidiary company, but by a contractual supplier, let's say. So I understand perfectly that the solution isn't the best, and probably Article 8, Paragraph 5 is not an effective provision. But at the same time, I hope that a specific solution for these very complex issues will be found. Thank you.
Thank you very much. Marc, do you want to comment?
I just want to say that I support the proposal of Catherine. We have to amend Article 8, number 1, with the number 1 bis for the human rights violations to include the subsidiary or the supplier. For example, for evidence questions, it might be useful to have them included in the proceedings and not only to sue the parent company. And this is a slight amendment, and Catherine pointed out how it could be done. Yeah.
Thank you.
Thank you.
Eduardo?
I'm just going to be very brief because I've seen that Geert mentioned in the chat that he wants to take the floor again to answer these questions. I'll just say briefly that I side with Catherine mainly. And to answer partially what Geneviève Sommier mentioned in the chat, I think that the subsidiaries were joined because of this experimental nature of all of these claims, right? Like very few have reached anywhere the merit stage, and even less of them have even reached the finding for a victim. So I think that claimants, by joining everyone and anyone that they can join, they're just trying to maximize their chances on a practical level. I'll just conclude by saying that I was a big fan back in the day of the idea of universalizing the scope of application of all of the Brussels I regulation. So that's another reason why I support Catherine in her stance. Thank you.
Eduardo, just before you leave, let me put one other question in the chat to you in the light of what you've just said, which is that the extension outside the EU would bring a strong power and create difficulties with China and the USA. Do you think it would be an obstacle?
I understand that diplomatic tensions may arise, but I think that this is part of the game. And so I would just, sorry for being a bit partisan on this, but I would still push forward.
Okay. Chukwuma, now, do you want to come back to the question of Shell Nigeria and indeed any other comments on this? Because I rather abruptly interrupted your flow previously on the access to justice question.
Well, I mean, I won't really be saying much. I mean, the only thing I would really like to say on the, I mean, I hope I'll be forgiven for dissenting, because when I look at Article 8.5, I'm not sure I have so much problems, Article 8.5. Personally looking at Article 8.5, because the subsidiary may not necessarily be domiciled in the EU, you know, and you would have to sue under the member states' national procedural rules. So my impression of Article 8.5 is that in such a situation, you can just sue the subsidiary and the parent company for any alleged human rights related abuse, and probably any contractual relationship the parent company has with any other company contractually. So I think in the Shell case, it would have been possible to rely on Article 8.5. That's the impression I have about the provision. You know, the only thing I would like to say is that I think it will probably have reduced the time lag that the case would have lasted for, at least from the procedural issue of private international law jurisdiction. I think those are the only comments I have to make.
Thank you very much. If I can just be allowed a comment as well, I'm with Catherine on this, that we would be better dealing with this in Article 8.1 bis, really, than 8.5, because 8.5 provides effectively an additional forum, but only against defendants domiciled in other member states, and half of it goes to create a jurisdiction that is created anyway by Article 4. So it's not an ideal piece of drafting. It seems to me that makes some kind of sense. We have one further comment, which I gather Geert wants to provide an answer to, but I will read it out for everybody, from Bennett Ray, who says that given the developing nature of parent company liability across jurisdictions, doesn't increasing the number of available jurisdictions potentially offer a wider palette of options to claimants to select the jurisdiction which presents the least obstacles or offers the most favourable settlement landscape? The Ontario Court of Appeal recently analysed the UK case law, including Chandler and Cape, Vedanta and Okpabi, and concluded that the one ground for declining jurisdiction was that the local law, in that case Bangladeshi law, was likely to develop along similar lines. And the case referred to is Das against George Western Limited, 2018, ONCA 1053. So thank you for that, Benedict Ray. My own, if I can be allowed a brief Brexit reflection, if I may, at this stage, my experience is that while we have been party to the Brussels I regime, the mandatory nature of Article 4 in particular has stopped a whole load of jurisdictional disputes which would otherwise have existed. Since Owusu, it's been perfectly plain that cases have been capable of being brought in the UK, which would perhaps not have been brought in the UK, but for the mandatory nature of Owusu. That's not necessarily always the case, because if there is access to justice denied in the natural forum, or the appropriate forum, to use English terminology, then England may be the appropriate forum, and a forum non conveniens application would not succeed. And we've seen that in a case of Lubbock and Cape in the House of Lords. But I think that having a clear mandatory rule is a great advantage in these areas in jurisdiction, to save the mini trial that Lord Briggs was referring to in Shell and Vedanta. Right. I think unless there are other questions at this stage, I have a further comment.
If you have 2
give you
minutes.
the floor, I'll give you the floor again in 1 minute. Don't worry. I'm just going to say two further points. Benedict Ray clarifies his point, said it was the one ground among many, not the definitive ground to refuse jurisdiction in this case. I'm going to now revert to our two principal speakers on this. Catherine, if you want to go first, that's fine, and then we'll come to Geert.
Well, I had a question in the Q&A, which I tried to answer in writing, but I couldn't. So I'm answering orally. The case that I mentioned on forum necessitatis from French Cour de Cassation is NIOC, N-I-O-C. And I would be happy if the person is leaving me an email address. I would be happy to send a copy of the case with the references. Other than that, I think it is very important to have mandatory rules. I have said to the UN exercise for a binding legal instrument that we should really make sure forum non-convenience cannot be pleaded before the court. That's absolutely essential. Whatever we do in the UN, that at least should be done. And I think in the new draft, I think Claire, we have looked at it together. The new draft does incorporate a non-forum non-convenience rule. Sorry.
Catherine, just while you have the floor, would you like to comment on the potential clash with China and the USA and no doubt other countries of strengthening the European jurisdictional rules?
I don't think the US would mind, because the US Supreme Court has been very clear. We don't want those cases. I mean, it's Kiobel, it's Daimler, it's Jesner Bank. They have been very, very clear, and I don't see the new court as being less or more inclined to give a jurisdiction to those kind of cases. So the US will be very happy that the EU is taking the lead. China. The messages we hear from China are actually a bit difficult to decipher because they are starting to be active on the corporate social responsibility issues, which they have not been in the past. So it's interesting to see what we are getting from China. I'm not sure. That is not something that I think is easy to assess. But for the US, I have no hesitation to say they will be very happy.
Can I just add one point on China? Because it's clear that in recent years, perhaps even recent months, the Chinese have been rapidly developing their procedural armory in international cases. And I'm thinking in particular in the patent field, which of course is a different field from this, but they have started adopting anti-suit injunctions to restrain parties in other countries from judging infringements of Chinese patents. Now, once that particular genie is out of the Chinese bottle, it may be hard to contain, and it gives rise to the prospect of substantial jurisdictional battles on a global level. So I'll throw that little thought into the melting pot here and hand the floor to Geert.
Yeah, thank you. I've tried to answer some of the questions in the box as well, but it's indeed, and thank you for those questions. I think on the issue of various jurisdictions being available, it's interesting to see how in the courts in England and Wales, at least, there seems to be. This is a high, a first instance judge, so we probably shouldn't read too much into one or two particular cases, but there seems to be a sentiment amongst the judiciary to want to somehow direct the forum choice amongst the many fora that are available to claimants, which, at least under the common law, is not something which I think is acceptable. If fora are available to you, then unless there is a clear abuse of process, which arguably there isn't in these cases, then you should be able to proceed. So I think that's not a good development. Of course, that sits uneasily with some of the civil law jurisdictions where there is more of a tradition of steering claimants' litigation strategy than perhaps there is in the common law. I also agree, to finish with, to finish my intervention here with what Catherine said on forum non-convenience, and that's exactly what worries me about the application of Article 33, 34, and the direction that they are taking in at least England and Wales. There's different noises coming from Rotterdam, for instance. It'll be very interesting to see, by the way, how the Dutch courts will react to what seems to be an ongoing case against Norsk Hydro in the Netherlands, where there also seem to be related cases pending in Brazil. So now that the onus seems to be shifting a bit more to the continent, perhaps in these cases, it'll be interesting to see how they will react to what is effectively a forum non-convenience light in Article 33, 34.
Fine, thank you all very much indeed for your contributions on this jurisdiction question. We've taken a little over an hour on it so far, and I feel that we've identified one real improvement that could be made to what the European Parliament has been proposing. There seems to be a fairly widely shared view that it needs to be wider than merely member state domiciled defendants that we're providing a jurisdictional rule for, and apart from a forum necessitatis. But there's much more work that can be done on this field, and the internationalization of the Brussels I regime is something that should probably remain under general discussion, as it was some years ago as well. I think it's time now to move. We have a further question, but that relates more to the applicable law, so I'll leave that for the moment. I think we should now move to the applicable law topic. As you know, a new applicable law article is proposed for the Rome II regulation, and this will be addressed by Professor Angelica Bonfati and Eduardo Álvarez in the first session now. So I hand over to you. I think you're going to do a joint presentation, which is excellent. Thank you.
Exactly. So good afternoon, everyone. Angelica and I have been entrusted with the task of presenting the proposed Article 6A on the law applicable to human rights related torts. I'm deliberately using this shortcut instead of the long paraphrase using the draft legislation, and I'll use it again. So we're going to begin. We have 10 minutes each, but we decided to try to put things together, and we're going to begin in the first slide by walking you guys quickly, ladies and gentlemen, through what happens at the moment when somebody sustains damage in the context of business-related civil claims for human rights violations. Well, once jurisdiction is asserted by a court of an EU member state, irrespective of the basis for doing so, then the determination of the applicable law goes through Rome II through its general rule, which has 3 paragraphs, as many people will know. Paragraph 1 is the main provision, lex loci damni, place of crystallization of the damage, law of the place of crystallization of the damage, irrespective of other considerations. Second paragraph, exceptionally when victim and tortfeasor have a common habitual residence, when the law of that place will apply. And then there's a escape clause, Article 4.3. So when there is a legal system that is more closely connected to the facts at stake, then the law of that place will apply instead of the laws in paragraphs 1 and 2. Now, this rule just would apply at the moment to human rights violations in general. We have a specific rule on environmental torts, which is on the next slide, which is Article 7 of Rome II. Thank you very much for that. Basically, this provision roughly says that the victim can choose the law to be applied to an to environmentally related tort between the lex loci damni and the lex loci actus. This provision, Article 7, we understand has largely inspired the new Article 6A, which Angelica will introduce right now.
Angelica, I think you're still...
Yes, now it should work, doesn't it?
Go ahead.
So thank you very much, Eduardo, for your kind introduction to the Rome II. Now I will briefly present the new Article 6A, that is the amendment proposed by the European Parliament. Actually, given the fact that the application of the set of rules established by the Rome II regulation often lead to unsatisfactory solutions for the claimants. The European Parliament has proposed to insert a new article, Article 6A, specifically devoted to the business-related human rights claims. According to this new provision, in the context of business-related civil claim for human rights violations within the value chain of an undertaking either domiciled in a member state of the European Union or operating in the European Union, the applicable law with the extra-contractual obligations arising out of the damage is the law of the country in which the damage occurs, so the same as before, the so-called lex loci danni, unless, and this is the news, unless the claimant chooses the law of the country in which the event giving rise to the damage occurred, so the lex loci actus, or the law of the place where the parent company is domiciled, or lacking a domicile within the European Union, the law of the country where the defendant undertaking operates. Therefore, Article 6A provides victims of alleged business-related human rights abuses committed by European companies in third countries with the right to choose the applicable law with the highest human rights standards between the four different options. Another very innovative aspect of Article 6A, from my point of view, is its large coverage. In fact, it seems to me that according to the wording proposed of Article 6A, the chosen applicable law will regulate the non-contractual obligation arising out of the damages for human rights violations occur within the value chain. And when we refer to the value chain, the proposed directive explicitly defines it as including all the activities and the operation and the business relationship and the entities with which the undertaking has a direct or indirect business relationship. Thus, the reference to the value chain makes Article 6A particularly suitable to deal with cases such as the already mentioned Rana Plaza or Key case, where the damages were materially caused not by a subsidiary company, but by an overseas contractual supplier of a European undertaking. I leave instead the floor to Eduardo in order to deal with the other news and innovative aspects of Article 6A, please.
So thank you for that, Angelica. Basically, developing on the idea of selecting the law with the highest human rights standards that Angelica has just mentioned, this led us to discussing the elective structure of the article and the four connecting factors which are included therein, which in my opinion are to be celebrated. So the four potentially applicable legal systems in reality are three in principle, because the third and fourth connecting factors would kind of exclude each other. But what is the reason for having four potentially applicable laws? Basically, what the European legislator would want if this proposal went forward was to pull upwards the level of protection of victims, getting corporations to adjust to most stringent one. And how exactly so? Well, here's where the inspiration and the link between the proposed Article 6A and Article 7 becomes obvious. If we go back to the explanatory memorandum to the Rome II proposal, that memorandum suggests in respect of Article 7 that it is based on a policy of prevention through incentives to reach a higher level of protection. So in a nutshell, what Article 7 wants and what proposed Article 6A would want is allowing the victim to choose the law that provides for bigger compensation, and that this will incentivize potential tortfeasors to either invest in prevention and or adapt to the law with the most stringent standards. Now, for corporations, and I know this is going to be controversial opinion, but I believe that for corporations, ascertaining which law that is not that complicated. I know that Professor Jan von Hein, which I believe is in the audience today, has said that for victims, it may be hard to ascertain which law is the most beneficial one. I would say that this is a price to be paid for having the option of choosing and trying to maximize. I'll briefly conclude on this by saying that the 4 connecting factors in principle are in a non-hierarchical position, even if lex loci danni is the default when victims do not choose. And as regards to the very specific prerogative of choosing for the victims and not for the courts, it is not the courts who choose. I would say that I prefer this configuration as it allows allows victims to better seize their own interests. In other words, there's a choice of law empowerment of the victims. I'm handing back the floor to Angelica on this because I know that she wants to talk about this in connection with the idea of the closest connection.
Thank you very much, Eduardo. Yes, another aspect that in my opinion is worthy of consideration in this regard is that the introduction of this special choice of law provision for the business-related human rights claims will allow victims of human rights abuses to have the law of the parent company applied with certainty, which means upon their own request. Instead, under Rome II regulation, as you have already explained, the application of a law different from the lex loci danni is possible only in case it is considered as the closest connected law pursuant to Article 4, paragraph 3. However, such an assessment depends on a complex and discretionary judicial evaluation that basically aims to verify that on the basis of the circumstances of the fact, it is clear that the tort is manifestly more closely connected with a country different from the country where the damage occurred. So the practical implementation of this criterion, the criterion under Article 4, paragraph 3, has often been criticized as leading to ugly, unforeseeable outcomes in practice. For instance, its application, as recently recalled by Geert Van Calster in a recently appeared post, was claimed in a case, the Amida Begun versus Maran, where the court, however, decided that the test is not satisfied because the accident occurred in Bangladesh, where also the claimant and the witnesses live, thus rejecting the claimant's submission, according to which the case was more connected with the English law. To do the long story short, even though such a very sophisticated private international law criterion would thus theoretically represent a suitable tool in order to grant victims of human rights violation an acceptable solution, in practice, its application has proved to be unsatisfactory for victims, and thus, which is something justified if we think that it's provided as an exception to the functioning of the law lex loci danni. Thus, I think that by contrary, the introduction of Article 6A would lead to the application of the law chosen by the victims with certainty, and with no need to demonstrate its closer connection, and this would be necessarily favorable for victims to obtain a fair compensation. Obviously, there are other benefits arising from Article 6A and the other connecting factors, and so Eduardo, please, I give you the floor on that.
Thank you very much. It occurred to me that we have not moved the slide, so perhaps we could move the slide so that, yeah, thank you very much.
Here we are.
Hello. So what comes up next is that we would like to talk about the jewel of the crown jewel, sorry, the law of the domicile of the parent company. Now, I'll do this briefly because I know that Claire is very keen on this, and I'm sure that she will want to talk about this later. But I'll just say that it's a great addition that addresses the core of the policy debate on business and human rights and it addresses the demands that NGOs and civil society have historically put forward, which is having transnational corporations respond the way they would do it at home, between inverted commas. Now, why the domicile of the parent? Well, the law of the domicile of the defendant would not be sufficient in certain cases. For instance, where procedurally it was only possible to attack the subsidiary. Ultimately, the domicile of the parent just responds to the idea of trying to reach a legal system with higher standards where the leading company habitually operates. I know that this is a tricky point which will link back to the diplomatic tensions and etc. I would just like to address something very briefly, which is this provision in the context of global north, global south relationships debate and international relationships. I understand that some people consider this this connecting factor to be colonialistic, because we've had discussions on this, notably amongst the panel. I would like to say just that I politely dissent and consider the opposite. I consider that not offering this option would be colonialistic, and I'm happy to elaborate later on this. There is, however, a fourth connecting factor that we need to discuss, and I'm giving the floor back to Angelica so that she would do this.
Yes, thank you, Eduardo. Yes, I will pass to some few comments on the fourth connecting factor that goes in the same direction as the previous one, so giving the victims the possibility to choose the law with the highest human rights standards. But it's a very specific criterion, given the fact that this one to hit lacking the undertaking's domicile in a member state of the European Union, claimants can select the law of the country where the defendant undertaking operates. So it's a very specific criterion for the case that the domicile, the undertaking is not domiciled within the European Union. To be clearer, the provision should be read as the law of the member state where the undertaking operates. So not of the country, but of the member states where it explicitly operates. This criterion, I say that this criterion is very special because it extends the subjective scope of Article 6A as to make it applicable to the multinational corporations that do business in the European Union, even though the parent company is not domiciled in a member state. Therefore, it seems to me that this provision is fully in line with the scope of application of the proposed directive on human rights due diligence, whose Article 2 establishes that human rights due diligence processes and requirements shall apply to undertakings either governed by the law of a member state or established in the territory of the European Union, or on the other hand, governed by the law of a third country and not established in the territory of the European Union when they operate in the internal market, selling goods or providing services. Thus, Article 6A, the fourth connecting factors, basically provides the victims with the possibility to obtain that the law of a European member state is applied also when the human rights violations are alleged to be committed by corporation whose parent company is not domiciled in the European Union. And in so doing, these connecting factors extend significantly the duty to comply with the European standards on human rights due diligence and makes such a compliance a sort of preliminary requirement to do business in the European market. Finally, the inclusion of this fourth criterion is very far-reaching, as it might avoid that in the future corporations escape the application of the new provision, so the amended provision, by implementing restructuring and offshoring processes. What do I mean? That regardless of whether in the future the corporations will decide to move the parent company to an extra European country, as long as they will do business on the European market, they will operate on the European market, their human rights abuses will be potentially subjected to the application of the law of a member state where they operate, if the claimants so require. So the effect of this provision is very far-reaching. But I know that, Eduardo, you probably have a slightly different opinion, so I leave you the floor on this.
It is just a complimentary comment. Thank you very much, Angelica. Basically, it is the idea that we're often told that this kind of provision, if legislated, like if the legislative procedure went through, would trigger offshoring, like corporations are going to move away from Europe. Now, I think that this needs to be nuanced. There's empirical research by Eurostat, and it dates a little way back from 2007 through 2011, I believe. But they basically concluded that change in the legislation, specifically the regulatory framework, is amongst the lowest ranking factors that corporations consider in order to offshore. That's on the one hand. On the other hand, I would like to say that the point of this fourth connecting factor is precisely as Angelica was suggesting, disincentivizing, taking away the incentive to move away from Europe. I will not dwell much more on this because we're running short of time, and we have two final considerations that Angelica and myself would like to put forward, and each of one is going to present one of them, and then the other will respond. So I will begin by briefly considering the relationship between Article 6A, the proposed Article 6A, and Article 7. If we got to a situation where there was a coexistence between the choice of law rule on environmental torts and another human rights related torts choice of law rule, this may lead to characterization problems. Where do we draw the line? When is an environmental tort a human rights violation too, and when is it not? So I personally anticipate that if we enacted the article the way it is right now, there would be some problems as regards to the dividing line. And just to illustrate this very briefly, I assume that most people in the audience would agree that mine de potasse is just a common environmental tort situation. But what actually distinguishes it from, say, Milieu Defensif versus Shell, the case that was successful for victims a few weeks back in the Netherlands, the second case would typically be framed as abuses on human rights case, right? Same goes with Yuya versus RWE, the Peruvian farmer taking RWE to court in Germany for climate change litigation. Climate change cases are increasingly connected to human rights considerations. So all in all, these cases are not so different from each other as regards the human rights element. There may be a number of criteria that can be used to try to draw the line, but they can be contentious. So in the view of this, and in the view of the fact that there may be arguments arising from the European Parliament's report to understand human rights violations expansively and including and so as inclusive of environmental torts. This on the one hand, and on the other hand, the rationality of Article 6 and Article 7 is the same one. So one is inspired by the other, but the new one has more connecting factors. I would think that we should amend Rome 2 accordingly, and we should just get rid of Article 7 and use the new text for Article 6A as an over-comprehensive article for both human rights violation, including environmental human rights violations and just common environmental torts. But I think that Angelica does have a little different opinion on this as well.
Actually, it's not so different. I mean, I also agree with you that the suppression of Article 7 and the coverage by Article 6A of all the human rights related torts would be preferable for victims, given the fact that Article 6A gives victims such an open choice of law possibility. But it seems also to me that As the proposal stands now, we will necessarily need to qualify the claims as either environmental or human rights-based claims. And so we will need to enter into the issue of characterization, and probably we will distinguish them on the basis of the tort allegedly committed and the content of the claim themselves. So, so yes, I agree with you, but I fear that there will be no suppression, and then we will be forced to distinguish between the two. And then as you have announced before, I pass to the last point we have decided to deal with in our presentation. This last point concerns the status of the human rights, of the provisions of the Human Rights Due Diligence Directive. Exactly, we wonder whether they will acquire the status of overriding mandatory provisions once they will be transposed into the domestic laws of the European member states. And we wonder about the relevance of the acquisitions of such a status for the functioning of private international law. Indeed, according to several scholars, these provisions, the human rights due diligence provisions, should be considered as overriding mandatory provisions. That are provisions to be mandatorily respected regardless of the applicable law, as explicitly recognized also under Article 16 of Rome II. Now, if the human rights due diligence provisions are qualified as overriding mandatory provisions, this means that they shall also be applied in case the law governing the responsibility of the tortfeasor is the law of a third country. And this would be extremely useful in case the amendments we are commenting will not be adopted. So in case the proposal we are discussing will not be adopted, the fact that the human rights due diligence provisions are considered as overriding mandatory provisions will be a very useful tool for the victims. Because regardless of the fact that the extra contractual obligations rising from the human rights torts will keep being ruled in accordance with the law of the damage, nonetheless, the human rights due diligence provision will be mandatorily applied.
Angelica, if I could ask you, please, just to bring
Yes.
your fairly soon to an end so we can have time for discussion, please.
Yes, for sure. Obviously, I'm favorable to the introduction of Article 6A, the Constitution, but I'm in favor also of qualifying this provision as overriding mandatory provision. Just, Eduardo, I know that you disagree a little bit, so
yeah, I'll be brief on this. I think that conferring the condition of overriding mandatory rule to the transpositions of the directive, be it explicitly or through judicial interpretation, does not solve the problem in situations where somebody sustains damage. In other words, labeling the directive's transposition as OMR is not an alternative or substitute to having this choice of law rule, in my opinion. Why? Well, because the content of the directive is mainly regulatory and aims mainly at ex-ante prevention. The directive does not contain a comprehensive regime of civil liability, and the directive does not contain a sufficiently defined standards of behavior, in my opinion, that may be used to assess the tortfeasor's fault if we were discussing their liability within a fault-based framework. So all in all, I think that Article 6A is required, and otherwise Article 4.1 will kick in, and overriding mandatory provisions are not, considering that the transpositions of the directive as overriding mandatory provisions is not a solution. Thank you very much.
Thank you very much to both our speakers there. We now move to discussion on the applicable law question, and I'll give the floor first to Dr. Claire Bright.
Thank you, Alex, and thank you, Eduardo and Angelica. I'll keep my intervention very brief. Just to make a couple of points on this, I do, as you also said, really share the opinion that it's essential to offer claimants in this type of cases a choice of law that they simply don't have at the moment. And this is particularly important going back to what we were discussing at the beginning and the imbalances of powers that characterizes this sort of claims. It's not, in fact, it's quite common in relation to the so-called weaker parties in other settings to see choice of law options in order to sort of redress the imbalance. And this is something that I think would be very important in the context of business and human rights claims, to recognize their specificities and recognize that those imbalances of power, and I know Benedict Ray, who's in the audience, him and I wrote a paper on that while we were still doing our PhDs a few years ago. So this is a first point I wanted to make. On the possibility to open the choice to for the claimants to have the applicable law as law of the domicile of the company, again, I think this is very important. This would be very important to ensure higher standards, as our speakers have mentioned earlier. But it also makes a lot of sense because this is the law. This is a law that the company is very familiar with. So when we see commentators sometimes saying opening a choice of law to the claimants would create legal uncertainty for the defendants, it's not the case. If it's a law of the defendant of the company, domicile of the company, it is obviously a law that they are well accustomed, they know well, or they should know well. So I think this really solves that issue and that problem that might rise in relation to the legal uncertainty. And just to come back again, earlier I talked about the issue of applicable law on the Shell case, but in many other cases we have seen that the applicable law in practice denied the claimant access to substantive justice. Mark was talking about the Kick case. In the Kick case, eventually by applying the Pakistani law, the case was dismissed because it was time-barred under Pakistani law, and it wouldn't have been under German law. Same solution in the Boliden case in Sweden. So it's very key issues here in terms of access to remedy for the victims. And just finally, on the idea of making the provisions overriding mandatory rules, I think this would be important to ensure the effectiveness of the directive in relation, for instance, to the German draft that we have on supply chain due diligence. I'm sure Mark can talk about that. There is already expressly that provision that there would be overriding mandatory rules. We don't have it in relation to French duty of vigilance law, but when I was talking about someone in the French government that was involved in the drafting of the law, she mentioned that they would expect the French judge to consider these provisions as overriding mandatory provisions. Finally, I just a really last point. I think that as Rome 2 currently is, it completely relies on mechanisms of exceptions, so the overriding mandatory provisions in the public policy to allow for the possibility of the home state to be applicable. And I think this is not good enough. We really need to have built in some mechanisms that allow it not as an exception, not in exceptional cases, but really as a matter of principle for the victims to be able to have this law applicable, the home state law applicable to them. Thank you.
Thank you, Claire. Of course, in answer to one of the points that was raised in one of the questions, which has largely been covered, we know that overriding mandatory rules can be overriding mandatory rules of European law or of national law. And if you were to have overriding mandatory rules of European law as a part of the directive, any contrary provision in home state law would be contrary to European law. And so you can resolve that last problem that way. It is perhaps just worth reminding ourselves, why do we have options in the choice of law in these fields in favor of socially and economically weaker parties? And it is because if you're acting for a victim in this situation, you want to know the answers to three things. You want to know the standard of liability, including, for example, whether or not the law provides for strict liability or a reasonable care basis. You want to know what defenses there are to liability, including acting on the reliance of third parties or defenses of limitation. And you want to know what the level of damages are. And of course, Article 15 of Rome II is very important in this regard in concentrating that kind of issue in the hands of the applicable law. And if you provide a wider range of choice to claimants, you are actually tilting the balance in favor of socially and economically weaker parties. Right, so continue the discussion. Let's take us in turn. Mark, do you want to add anything on this applicable law question?
Yeah, just a slight little point. Indeed, the main question is if the duty of care is an overriding mandatory provision. And yeah, you explained it already. I think it's normal that at the moment we discuss it as an overriding mandatory provision because we have national approaches. We have the French approach, we have the German approach. And if those countries want to have their own law applicable, they must act with international mandatory provisions, because Article 4 of the existing Rome II regulation leads us to foreign law, to the place of the damage which is abroad. Now, if we would introduce the Article 6a, that would change the setting, because then we would introduce the principle of ubiquity, and the victim can choose then either the law of the place of the damage, or more important, the law of the habitual residence of the corporation, of the domicile of the corporation, and that would lead again to the law of the forum. And I think it's enough to limit the choice of law to those two connecting factors and not to the four. Geert Van Calster wrote an interesting article and comment on Conflict of Laws net, also Jan van Hein, and they explained that it's too much of choice of law at the moment in the proposed Article 6a, and I think it would be enough to reduce it to the two connecting factors, to the habitual residence of the company. Thank you.
Thank you. Let me just identify, so Catherine, I'll come to you in 1 second. Let me just identify a couple of questions that have come up. One of them is directed to Angelica, and you can perhaps deal with this when we come back to you at the end of this discussion. But the question is whether there's security in the jurisprudence or the literature on Article 16. That Article 16 will be applied to all human rights liabilities or due diligence liabilities. Would this need to be specified in the law? And we have a big discussion about this in Germany because of the German supply chain law. And he asked the same question in the chat. And there's an additional question about what are the options to include the contractors as parent company. In Brazil, we have a shocking case of Zara having contractors and subcontractors that will use slave labor and later not complying with the labor case agreement. No doubt is the allegation in that case. Right, Catherine, next for you.
Well, thank you, Alex. Just a few points. First, on the overriding mandatory provisions, I am not so sure I like that because it does leave a lot of leeway to the court. I would prefer a very precise provision saying that in any case, whatever the result is cannot be against putting effective human rights remedies in place or something like that. So it clearly shows that we are incorporating all the international law issues on these matters, and that the standard is a high standard. I understand the point that Eduardo was mentioning about colonialism, but I think in some ways colonialism may be useful. My second point is Article 17. Nobody speaks about Article 17. I'm really concerned about that Article 17. It allows companies to say, well, you know, I did whatever I was authorized to do. But the problem is really there because, in fact, in those countries where the damages are occurring, of course, the level of safety and conduct is much lower. So if we allow Article 17 to be used in those cases, then we are doing, even if we are giving a lot of leeway to victims, this is really an impediment. So I have proposed that we have an Article 17, but the other way around. What you couldn't do in your home country, you cannot do in the host country. Now, this is a harsh solution, but I think that's the kind of ideas that we should be working on. And my last point is about the fact that Rome II is not the end of the story, because in fact, we have some issues that are pertaining to the Lex Societatis, and Rome II cannot apply to those issues. So the problem is that for applicable law, and I'm usually not saying that, but for applicable law in human rights issues, business and human rights, I would advocate for a series, like a section, a separate section, or even a separate body of rules in the future document that is prepared at the EU level, instead of importing, because also we may have those issues with Rome I, because very often within the supply chain, we have contractual relations. So I think we should not work on Rome II. We should work on applicable law, specific rules in the future document that is prepared by the Commission.
Thank you, Catherine. Time is now very short, but Chukwuma, if you want to make a 1-minute contribution.
Try and be very brief. I think first I'll talk on the issue of ubiquity. I think it's a welcome development because it gives a good remedy to the victims of the alleged human rights, business human rights violations. And for me, it's a kind of better law approach. You know, although it's not really the US approach of better law, but it's a kind of better law approach because they have a choice to choose which law is most favorable to them. And secondly, I also think it's also advantageous that they didn't use the escape clause in Article 4.3 of Rome II regulation, because the escape clause can actually lead to a law that's not favorable. It doesn't necessarily it doesn't necessarily have to be the closest connecting law doesn't necessarily have to be the favorable law. It can also be an unfavorable law. And finally, I also agree with Eduardo. Finally, that it's possible that the concept of environmental damage may have to be extinguished from so that human rights, business human rights claims just covers all those issues, including environmental damage. That's what I have to say.
Thank you very much. Geert, the floor is yours for a very brief contribution.
I just wanted to, thank you very much. I just wanted to very briefly add that one element that we should also think about, and we haven't really talked about much, is the meaning of in the context of business-related civil claims. When you look at Rome II, it typically uses arises out of, and in our appeal in Begum and Maram, that was one of the issues which caught the Court of Appeal's attention. What does it mean when a damage arises out of something? That causal link is not much discussed in Rome II, and I think it's an important point of attention for this proposal as well.
Thank you. Now 30 seconds each. First, Eduardo.
I would like to just join what Geert said, and I would say that in terms of legislative technique, the draft term is quite baroque of many of the provisions, not only in the directive, but also the choice of law and jurisdiction provisions. So I would advocate for simplifying and clarifying things. And then I'm going to give the floor to the others because that's more than 30 seconds.
Angelica, you have the last 30 seconds.
Yes, just on the overriding mandatory provisions and German law, just reply yes, there is literature on the human rights due diligence status of overriding mandatory provision. It would be easier if it is qualified. There was a jury committee amendment on this, but it was rejected, but doesn't mean that these provisions cannot be qualified as already mandatory. And a comment on Catherine Kessedjan, I really appreciated the comment on the standards of safety and conduct that we haven't taken into consideration properly, and I fully agree with you.
Right. Thank you. Thank you all very much indeed. There was a brief clarification from Geert Van Calster in the chat because he was afraid he spoke too quickly. So by all means, look at that. Our time is up, and I'm afraid we may be cut off electronically. So it just gives me enough time to thank Claire and the others at the Nova School for organizing this, and to all our panelists for a very interesting contribution. I gather that the video of this will be posted on the Nova School website tomorrow, and I would hope that the content of our discussion today will be heeded by the European Parliament and other parts of the European legislature when they come to consider the European Parliament's report. Thank you very much, last and finally, to all the participants, 197 of you at the peak. And so thank you very much indeed for attending to the seminar this afternoon. The next seminar in the series has been posted in the chat. Thanks very much indeed, and goodbye, everybody.
Thank you, Alex. Great monitoring.
Thank you.
Goodbye.
Bye.
Bye all,
Thanks,
bye.
Claire, thanks again for convening the meeting. Bye.
Thank you to all. Thank you. Bye-bye.
Thank you, Claire.
Bye, Claire.
Bye.
Bye.
Thank you.
Everybody.